Hello, everybody. How you doing today? I'm here with Travis. We're going to go ahead and talk about something you guys have probably been hearing about. Whoops, hold on. Something you guys have been obviously seeing mentioned in just about every live video for the past 2 days because Falcon Apata keeps coming in and telling us all about it, which is the and also on Facebook groups. There's some other people in the mixed groups that are really gung-ho about it, so you can't help but hear about it. But it's the lawsuit that has been filed by one of Kathleen Zellner's former clients against her, basically saying that she didn't really do her job, basically, and didn't defend or didn't represent him as effectively as he feels that she should have, or the way he puts it is zealously as she should have. And so he's bringing a suit against her. I've gone through it. Travis has gone through it. We're gonna kind of talk about it here today, and I want to just point out one thing that you guys hear me on my channel talking about how the presumption of innocence is important with murder suspects and people who you're accusing or we are accusing and that sort of thing. But I think that also applies to Miss Zellner here with this filing from Letherial Boyd, that Zellner also gets her presumption of innocence. And whatever you see in this document, just realize Zellner also probably has her side to tell, that of a lot of facts that most likely Letherial Boyd and his lawyer left out. So we're going to hopefully eventually hear both sides of this, and then somewhere in the middle, we're going to find the truth. But, just want to give that little disclaimer before we start. Anything you wanted to say about this before we start, Trav? You want to say hi to everybody?
Hey, everybody. I think you covered it really well.
All righty. Okay. So.
Good night, everybody. See you tomorrow.
Yeah. Okay. So to get into it, let me get it up here on the screen for you guys. We're going to go right through the document. Oh, I gotta get the document up. I'm not going to be able to monitor the chat while we're going through this, guys, so keep that in mind. All right. So this is a copy of the complaint, basically, from Letherial Boyd. It's in the Circuit Court of Cook County, Illinois. That's basically where the jurisdiction is on this. It was filed on the 27th of December of 2018, which is, a week and a half, 2 weeks ago. Well, no, sorry, about a week ago. Anyway, so this is against Zellner, and essentially, like I said, Letherial Boyd is a former client of hers, and he is now bringing this litigation. So this is just saying that he is bringing this against Kathleen Zellner. The introduction is parts 1, 2, and 3 here are just a brief kind of synopsis of the case against him when he was wrongfully convicted. Essentially, it just describes a nightclub shooting where some people were shot outside of a nightclub, I guess. It was actually the murders were actually performed by rival drug dealers of the people who got killed, but somehow the police went ahead and zealously went after Letherial Boyd, who didn't fit the description, and built this case against him and kind of maliciously prosecuted him for this crime. And the actual rival drug dealers kind of got away with what they had done. So that's basically what this first part is describing. Then here in 4, it says, unlike some victims of wrongful convictions, however, Boyd was not a victim just once. He became a victim all over again when the person he trusted to help bring him justice, Kathleen Zellner.
Sorry, I'm not sure about that.
Hey, Alexa, how are you?
Oh, Lord.
Nice to see you, Alexa.
How did that happen? I didn't say her name.
Play Stacy, Alexa.
It's a good thing you're in my headphones, Travis. So,
I know, but I'm just trying to fill a gap for you. I'm stretching.
So I said it's a good thing you're in my headphones. Otherwise, she'd still be going. Anyways, so let's see here. He became a victim all over again when he, an attorney who intervened in Boyd's relationship with his prior counsel in order to become the lawyer, but who nevertheless promised to zealously fight for him to receive justice. Instead, botched his federal civil rights case and then abandoned prosecution of the case when it did not work with the counsel's personal schedule to pursue it. Mr. Boyd now brings this complaint seeking restitution against Ms. Zellner for ruining his one chance to receive justice for what happened to him. So he's claiming that Zellner basically botched his chance to get, his settlement for his civil rights settlement for the wrongful conviction that he was, put through, essentially. Lethera Boyd is 52 years old, a resident of the state of Illinois. Kathleen Zellner operates in Illinois. The jurisdiction for this is going to be Cook County. So here are the factual allegations as per Lethera Boyd and his new counsel, his new lawyer. In 1990, 2 men were shot multiple times outside of a nightclub on the north side of Chicago. Police arriving at the scene found one of these men dead and another unconscious and paralyzed from the waist down. Responders rushed that victim, Ricky Warner, to the hospital. Multiple witnesses saw a man walk up to the victim who appeared to have been selling drugs outside of the nightclub, pulled out an automatic weapon and shot them. They gave description of this man that did not match Mr. Boyd. Despite that, police placed Mr. Boyd in lineups, but unsurprisingly, as he was not the shooter and looked nothing like the shooter, no one identified him. Detectives involved with this case visited the paralyzed victim, Mr. Warner, at the hospital and falsely claimed that Mr. Warner had identified Mr. Boyd as the shooter and gave them other evidence that pointed to his involvement. So basically, these crooked cops were building, were screwing him over. We've seen it, the story before, basically. Because of what members of the Chicago police did to fabricate evidence and maliciously prosecute Mr. Boyd, he was wrongfully convicted and sentenced to 82 years in prison. Ms. Zellner began representing Mr. Boyd in 2013 after WGN and other post-conviction counsel, as well as Mr. Boyd himself, had already conducted significant investigation into Mr. Boyd's case. Mr. Boyd had already sought for the Cook County State Attorney's Office's Conviction Integrity Unit to review this case. Folks, that is not the first time you've heard that that Conviction Integrity Unit mentioned on my channel. This is the Cook County Conviction Integrity Unit. This is the Conviction Integrity Unit that was started by Robert Milan, and all of you know how much I love Robert Milan. He's one of the most ethical prosecutors I've ever seen in my life, and I love him to death. That's this Conviction Integrity Unit this one here. It's his baby. He started it. It's his one. And so I just wanted to point that out because when we're going through, because I love Robert Milan so much and I think so much of him. The Cook County CIU is the one he started. And I just think that's awesome. I wanted to point it out. All right. The CIU had already conducted its own investigation, met with Mr. Boyd and his then counsel, and become convinced that there was a serious problem with Mr. Boyd's conviction. Mr. Boyd and his wife also conducted a nationwide signature campaign to raise awareness about his case that had resulted in many people's learning about and supporting his cause of innocence. Knowing that Mr. Boyd was represented by counsel and having learned that Mr. Boyd was close to receiving relief, Ms. Zellner, I would say this is him making a theory, right? He's guessing at why Zellner chose to seek to be his counsel at that time, I would say, right? That's not really factual. Would it? I don't know. Anyway. Any thought about that, Travis? No? Okay.
Well, no, it's what they're stating in number 14 is that would be they're trying to allege an ethical violation. So
right.
There's a couple of different ways to create liability for legal malpractice. One is showing that you've breached the rules of ethics, and the other is that you didn't hold yourself, you didn't perform within the standard of practice for that locality. And then if you're a specialist, you need to perform up to the standard of care of a specialist in that locality. But they're basically throwing this in here. It's frankly irrelevant. And they could file a motion to strike it, but they're trying to show that Zellner
came in at an opportune time.
Poached the client is how we refer to it.
Right. So what it goes on to say, folks, is that Miss Zellner nonetheless reached out to him at that point when he's saying he was close already through his previous attorneys and his own efforts and him and his wife's efforts and through the Cook County CIU, that he was already close to the point of, being exonerated and all that sort of stuff and being eligible for relief or a settlement basically. And so he's saying that just at that opportune time is when Zellner swooped in and contacted him. That's his claim.
Well, we got to be real. We need to be real. We need to be real careful here about who contacted who. So
exactly what I was getting at.
They're alleging that Ms. Zellner reached out through another attorney in her office to Mr. Boyd's wife. And because an attorney cannot contact a person they know who is represented by another lawyer. And if you did that for purposes of, soliciting them to hire you, that's actually a crime in some states. In Texas, it is a crime, and it's called barratry. And so, and they do prosecute attorneys for doing that, for committing barratry. And so even here, they're very careful, saying, they've done it artfully. She reached out through another attorney in her firm to the wife, but one thing we'll never ever know, until the thing moves along, is there may have been a prior relationship, professional relationship, and I'm sure there probably was. That the Zellner firm does post-conviction relief and exonerations. I'm sure the other attorney in her firm was probably speaking somewhere at some sort of conference or something, and I could just see, Ms. Boyd, was it the wife in the previous paragraph, started a signature campaign.
Him and his wife, yes.
So, I'm sure he ran into, this other attorney ran into his wife, and what the flip side of this could be, and it wouldn't surprise me at all, is that Zellner and her firm, what they contend is, no, this lady had been sending letters to Zellner and had been trying to get her to answer the letters about taking the case. Exactly like Stephen Avery, except there's a big difference in the Stephen Avery case. We'll get to that later. But hey, I've been sending letters to your firm. It's so nice to meet you in person. I'm glad I ran into you here on this conference on actual innocence. And I'd really like if Ms. Zellner could take a look at this case. I would not be surprised at all.
You're saying that there may be something like that exists before.
So this is a complaint, and we'll get down to the bottom of it later, but this is not under oath. It's not verified. It's strictly a lawyer.
It's a story.
His story of what he thinks he can prove. And then, by the way, you can amend these complaints as things go on. And so by the time of trial, you don't know what paragraphs are going to remain. You still have to have the minimum to allege a cause of action. But if it turns out that some of these things aren't what the client told you, you can go in and amend it to match with what the discovery is. But go ahead from there.
Right. Okay. Let's see here. So,
Hey, Falcon, you're talking about something completely different right now. So you're wasting everybody's time. That's the decision on the motion for summary judgment that was appealed, which I've read, but there's a lot of stuff in between the lines that you're leaving out. One of the things you're leaving out is that this gentleman had a piss poor case, unfortunately, but we don't need to get into that at this point. We're just looking at the complaint, but I'll be happy to get into that stuff with you about what else the judge said about that the plaintiff, Mr. Boyd, unfortunately contended things at trial, and they talk about the trial, but we can't cover both at this point. All we can do right now is go through the
We'll come back to this, obviously, and cover more of the aspects of it, at some point. But we just want to talk about this kind of today and give people an introduction to what it's saying. But once again, even you, Falcon, this is one side. You're only hearing one side of it so far right now. You're not hearing the other side. And I will say that there's a few things that Lefthero Boyd and his counsel say in here that have me wondering, and I do want to hear what Kathleen Zellner has to say to explain some of the claims that they're making in this thing. So, I mean, me personally, I know it's like Sean Atwood says, guys, when two opposing parties walk into court, it's a big theater show, okay? And each side is basically trying to paint the other side as the devil and themselves as an angel. And that's the way it is. And whoever puts on the best show generally wins. And that's what this is, part of that process. So, like I said, we're going to end up seeing this. We're going to end up seeing Zellner's side respond to it. We're going to be able to see both sides and what they're saying. And like I said, somewhere in the middle, we're going to be able to discern where the truth lies. That's truly what I believe. So,
Ruh-roh.
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 What's the matter?
No, nothing. Scooby came in.
Ruh-roh. Hey,
okay.
Scooby.
Go ahead.
So Ms. Zellner met with Mr. Boyd at the Illinois Department of Corrections and convinced him to fire his counsel and to retain her instead. She told him that she had a close relationship with the state's attorney's office and persuaded him to terminate his prior relationship and to retain her instead. Mr. Boyd subsequently signed a retainer agreement with Ms. Zellner and her law offices. This retainer agreement included an agreement both that Ms. Zellner represent him in his post-conviction proceedings and that she and her law offices would represent him in future litigation pursuant to 42 USC 1983. What's that, Travis?
The 1983 action. So that's a civil rights action.
Oh, okay.
42 is the chapter. USC is United States Code, okay. And then section 1983. There's also 1984, but most civil rights violations being jailed and held in jail because your name is Joe Smith and they don't distinguish you from somebody else named Joe Smith, breaking into your home with a search warrant turns out to be the wrong house, conspiring to frame you, anything that's a violation of one of the constitutional amendments, or Constitution or the amendments, specifically the 14th Amendment, due process would apply to prisoners. But, we'll get to it later. Simply because you were wrongfully convicted doesn't rise to the level of a
civil
rights violation.
Okay.
Being a negligent police work does not rise to the level of a civil rights violation. You have to show a conscious disregard. You knew somebody was innocent and you went after them anyway, or you have to show deliberate indifference, that a detective was constantly arresting and framing the wrong people. To hit the city, to hit a governmental entity, you have to show that there's a deliberate indifference.
Okay. All right.
Now, but this is an important point. So this lawsuit is not for a 1983 violation. It's for attorney malpractice, but we'll see later on.
Well, but the civil suit she was filing was for his wrongful conviction or something that happened during it, right?
Right. And we'll see that as part of a legal malpractice case, this attorney for Mr. Boyd would have to prove, if it went to a jury or went to trial, would have to prove that there was a reasonable likelihood of prevailing in the 1983 action, which we will, as we discuss this, that's a major uphill battle for Mr. Boyd. And we'll get to that as we come along.
Right. Okay. Let's see. After Mr. Boyd retained Ms. Zellner in her law offices, the CIU continued its investigation in his case. On September 13th of 2013, Mr. Boyd's conviction was vacated. The charges were dismissed and Mr. Boyd was released from prison. The Circuit Court of Cook County later granted Mr. Boyd a certificate of innocence, recognizing that his conviction was overturned in circumstances indicative of his innocence. Ms. Zellner and her law offices thereafter filed a federal civil rights lawsuit on Mr. Boyd's behalf against the city of Chicago and police officers Richard Zuley and Lawrence Thiessen, Steve Schrosch, and John Murray in the United States District Court for the Northern District of Illinois, case number 13 CV 7512. Ms. Zellner.
Just in the interest of full disclosure, the Schweddies from Scotland are related to the Schorsches from Chicago. But I'm sure they would agree that the Schweddy Christmas balls are better than the Schorsch Christmas balls.
Right. God. Ms. Zellner did not zealously litigate this lawsuit on Mr. Boyd's behalf. The earlier WGN and post-conviction litigation had already revealed significant evidence that would have allowed Ms. Zellner to successfully pursue relief for Mr. Boyd, but she and her law offices failed to develop all the available evidence and, more importantly, prepare and present written briefs sufficient to overcome the defendant's written pleadings. Given the strength of the civil rights case against Detective Zuley and the other defendants, any reasonably competent civil rights attorney.
Let's just pause for a minute.
Okay.
Number 19. I'm going to be really interested to see how that develops. I mean, and I'm not just talking making a murderer and Stevie's appeal. I've looked up other cases that she's been involved with, and she's run them all just like what she's seeing in Making a Murderer. So I just want people in the back of their mind to think about this allegation, and that's all it is an allegation.
Right. It's what he says.
That Ms. Zellner,
we've got the he said here, but we don't have the she said yet.
Right. That she did not zealously litigate this lawsuit, and that it had already been done, and she and her law office failed to develop all available evidence. More importantly, prepare and present written briefs sufficient to overcome the defendant's written pleadings. But this part, she and her law office failed to develop all available evidence. Everybody can have a bad day. Everybody can have a bad case, but I want people to think, okay, based on what I've seen and what I've researched about what Zellner's done on behalf of Stevie and, these other 18 or 19 exonerees. I mean, have you ever seen her not zealously litigate a lawsuit or successfully or fail to develop all available evidence? I mean, she goes out and uncovers evidence that no one even thought of before.
Yeah.
But anyway, go ahead.
You're right. So yeah, like I said, this is the he said. We certainly need the she said. So let's see. Any reasonably let's see. Any reasonably competent civil rights attorney would have been able to establish a factual record sufficient to survive summary judgment. This was not
so that's a standard. In court, they would have to prove that the conduct of Zellner and her law offices. I don't know. Let's see. How did they allege it? So I guess it's just it's a partnership. It's not a limited liability company or a professional corporation, but they've sued Zellner and her firm. So the standard at trial, they'll have to get experts to come in and say, this particular thing that Zellner did, that fell below the standard of care for, a reasonably competent firm in the Chicago area or in the Cook County, or they'll say, that she failed to do something, but they've articulated the standard there.
Yeah. So yeah, and they're basically saying,
that's a buzzword that you're going to keep, a buzz phrase you're going to keep seeing over and over and over again as this lawsuit proceeds, and they'll be talking about
any reasonably competent civil rights
attorney would have been able
to overcome. Right. Okay. So this was not the only piece of federal civil rights litigation that Ms. Zellner filed on Mr. Boyd's behalf. During his time in the Illinois Department of Corrections, Mr. Boyd developed a very serious eye condition, disc atrophy, which various people associated with IDOC ignored and failed to treat. Their conduct resulted in Mr. Boyd becoming permanently blind in his left eye. Mr. Boyd wanted to seek relief for these problems and sought to file a civil lawsuit in this case too. He and Ms. Zellner signed a standard retainer agreement for this litigation as well. Ms. Zellner then filed a lawsuit on Mr. Boyd's behalf in this case in the United States District Court for the Central District of Illinois, case number 14 CV 3117. Ms. Zellner negotiated a settlement for Mr. Boyd against certain of these defendants in this case for a significant amount of money, for which she received her portion of that retainer. This matter settled in August of 2016.
Oh, so, that's so funny. Maybe that allegation up above about, we knew, her firm specializes in medical malpractice.
Right.
That's their main bread and butter.
Right.
And they're tremendously successful at it.
Right.
The first 10, 12 years of my career, I defended doctors in hospitals in medical malpractice cases.
Uh-huh.
And, and if somebody's in prison, they'll pursue them there, but they're worth significantly less because juries, just if you have a child that's been injured by a doctor or, a good presentable plaintiff, people just don't put this. If you had the identical injury or the identical suffering for two people, one's in prison and one's, stay-at-home mom, the juries just don't give the same money to prisoners, but they can still be pursued. But she filed a law. So this statement earlier up that we read earlier about higher up about that, she sought him out because she knew he was about to wrap up this case and she wanted the civil rights case because it was a great civil rights case under 1983. This tells me, just even reading between the lines, that
that they knew each other from this in
this
2016.
they were possibly seeking out her for this horrendous treatment he received in prison, and then very easily could have said, well, while you're doing this too, can you please represent me on my exoneration case? And she may have said, well, you've got these other attorneys. They seem like they're doing a great job. I don't know there's much I can do for you. Who knows?
Yeah, right. We need the other side of the story, certainly.
But isn't it interesting in paragraph 22 that she ends up representing him in a medical malpractice case that she settles for a significant amount of money. Of course, they don't bother to put that in there. And the amount that she got for him.
I think he's worried because of the creditors that'll come after him if you put a number there. We'll get to that later in the document.
I never even would have thought of that. That's interesting. Not that I haven't had people calling me to speed up a payment or whatnot, but that isn't that interesting. Okay, so that's settled in August of 2016.
Right. Let's see here. For reasons explained below, Ms. Zellner kept this settlement a secret.
Wait a minute.
Talking about.
We'll have to look up Illinois case number 14 CV 31117, and I can look that up through the PACER system.
Okay.
All federal courts have their documents available online. It's through a system called PACER, PACER.
Mm-hmm.
Anybody can set up an account and get documents. But normally 14 means that's the year it's filed.
Oh, okay.
Which is, when does he allege that they ran into each other?
That she reached out to him in 2016, I think is what it said at the top.
No.
Like in the opening paragraphs.
No, paragraph 16.
I think it was paragraph 4 or 5.
Yeah, paragraph 16 says, after Mr. Boyd retained Ms. Zellner in her law offices, the CIU continued to investigate this case. On September 13, 2013, Mr. Boyd's conviction was vacated. It was vacated in 2013. Now, you say up at the top under paragraph what? It's 2016?
I think they said it was, well, maybe I'm wrong, but it was up in the top in paragraph 4. They said up in the beginning is when they talk about her reaching out to his wife. Let's see where we're at now. Bottom of page 7.
Sorry to skip around, folks, but I just caught something on the date. Okay, Ms. Zellner began representing Mr. Boyd in 2013. That's paragraph 13.
Okay.
Okay. But so who knows? It's he may have lost the eye, and that my hypothetical seminar that the other attorney was speaking at that ran into the wife, that could have been a seminar on medical malpractice, and she came up and said, or atrocious prison conditions, or terrible medical treatment of prisoners, and she went up and said, my husband's losing his eye, or lost his eye, and we just don't know. But I'm sorry to interrupt. I just saw that 2014. So she filed the lawsuit right about the same time she got into the case. But okay, we're at paragraph 23. Sorry, folks.
Yep. Ms. Zellner negotiated a settlement for Mr. Boyd. No, we're not. We're past that. During the time the civil rights and denial of medical care litigation was pending, Ms. Zellner in her office continued to assure Mr. Boyd that her office would prevail on his behalf. As part of her effort to ensure that Mr. Boyd remained her client, she induced Mr. Boyd to take out litigation loans on the value of both of his civil rights and denial of medical care cases. Mr. Boyd ultimately took out several loans on the value of these cases, including a November 2013 loan from Oasis Legal Finance for roughly $5,000, a December 2013 loan from Law Cash for over $100,000, litigation financing from Fast Track Investment Company, LLC, a litigation funding company that eventually held a lien over Mr. Boyd's litigation in the amount of $476,000. And number 4, an investment offering from Lex Invest Fund, a New Jersey litigation funding company that proposed to conduct $1 million in fundraising to help Mr. Boyd pay back Fast Track and provide Mr. Boyd $419,000. The purpose of involving Mr. Boyd with these expensive litigation funding companies was to assure Mr. Boyd that Ms. Zellner would prevail in his cases, to induce him to continue to be her client, and to distract Mr. Boyd from the fact that Ms. Zellner was not zealously litigating his federal civil rights lawsuit for him. Again, his opinion. Mr. Boyd and his family did not fully understand the terms or the requirements of these complex.
Let me talk about 27 for a second.
Sure. Yep.
So, there are these litigation funding companies that, will loan people money, help with their lost wages, and all the security they do is they do a lien. And what they do it a couple of different ways. One is they harvest through attorney contacts and say, look, if you have a client, you can't, front all of the litigation costs because they're too high. We'll loan your client money secured by their proceeds in the lawsuit. This has been common for years and years and years. There's nothing unethical about it in doing it. They'll also, but the other thing they do is they mine. These companies can go to the clerk's offices and ask for a download, and they pay an amount for it. And so, yeah, we want every active complaint for malpractice. We want every active complaint alleging more than $50,000 involving a car wreck. We want, they can specify, they can just say every case we want, and then they send direct mail or, whatever, if they have email for the individuals. There's nothing unethical. They can contact the litigant, the person, the citizen who's represented by attorney. They can contact that person directly and say, hey, do you need help with your medical bills while your case is pending? Do you need help with your lost wages? Do you need help funding your case? So there's two ways that, at least two ways, and I've seen them do ads during the day. When you see all the attorney ads on CNN and all of that, you also see litigation funding ads. You also see how to, buy yourself out of a timeshare. And these companies charge exorbitant interest and so on and so forth. But it's a riskier type of loan. If these people don't recover in the lawsuit, the likelihood that the loan company is going to get their money back is, pretty dismal. But, I think they charge exorbitant interest and so on and so forth. And some aren't on the up and up. But there are two ways Mr. Boyd could have come in contact with. And a lot of times I'll have a case and I'll be going along. And even in criminal cases, they offer it, different financing packages to people. But, you'll be going along and then all of a sudden you'll get a letter, please be advised of our $75,000 lien in your case. Here's the written agreement between us and your client. that you will hold off, set aside the first $75,000 in recovery from the lawsuit. And it's like, oh my gosh, you got to be kidding me. And I'll call up the client. Hey, did you do a loan with one of these cost companies? And they're like, well, yeah, I did. Got a thing in the mail and I filled it out. And they said, yeah, here's 75,000. And you got to be kidding. We've been talking about from the very beginning that, this case probably has a maximum value of 50,000. You basically have, just signed your all your money away. And what'd you use it for? And they're big, well, I put a down payment on a car or whatnot. That's an extreme case, but I just want people to understand that these companies are around. They don't necessarily have anything to do with the attorney representing them on the case. Sometimes they do, because it's the only way that the case can be funded. So the choice would be, look, I'm sorry, you have a great case, but I just can't afford or risk putting $500,000 into experts to fund your case. And so I'm not going to be able to take it. But there's a company, I want you to understand, they're charging the equivalent of about 20% interest, but they may loan you money based on the value of the case. And so for some people, that's the only way that they can present their case. And then getting to this paragraph 27, that spin. It may be that Ms. Zellner had had little or no involvement in arranging for Mr. Boyd to have these companies. And this fundraising thing is really interesting. I hadn't seen that before. Lex Invest Fund, a New Jersey litigation funding company that proposed to conduct $1 million in fundraising to help Mr. Boyd pay back Fast Track, who loaned $476,000, and provide Mr. Boyd $419,000. So that's $8. So they would charge $100,000. They would charge 10%, which is standard for fundraisers, because $419,000 and $476,000 is $900,000. They were proposing to raise $1 million, but they don't allege what ended up happening with that. They don't allege that that money was actually raised, or that money wasn't paid back. It just sounds like, that was a proposal at some time.
Right.
Anyway, go ahead. Sorry to interrupt. We're at 28 now. Okay. Well, look what it says. Mr. Boyd and his family did not fully understand what they were signing. That's what the next sentence means.
Right.
So that's just, going to be baseless. Right. That's going to get tossed out.
But if they were seeking this money on a promise from Zellner that she was going to sell.
Look at what the sentence says. Mr. Boyd and his family did not fully understand the terms of the requirements of these complex lending agreements. So how much relief do you think a court's going to give you when you miss 3 payments on your car and they repossess it, and you start reading the fine print where it says they have the right to repossess your car, and you sue them because you missed work and you were fired? Everybody knows you have no lawsuit there. I mean, well, if you sign a document
saying you will make the payments and fail to do so,
So that's what all I'm saying there
Yeah.
is look at that fancy language for basically saying, you signed it, but you didn't understand it.
Right. All right. So
And here's this desperate thing. Mr. Boyd, who desperately needed money during the pendency of this litigation, gratefully accepted these loans. And so what they're alleging here is that, it was in what they're alleging is Kathleen Zellner held out all of these loans on a silver platter that don't even involve her law firm, and
so
said,
he just says that she encouraged him to do that.
at best, that's what she's saying, and that he was so desperate, anybody would have taken these loans, and then, but it's like, it's not like you didn't. They're not alleging this money didn't go for his benefit, that it didn't go for his quote obligations, or desperately needed money. I wouldn't be surprised if a lot of this was living expenses and things like that. Of course, they don't include the alternative. This is for Ms. Zellner to respond to, if it's even the case that she even presented any of these loan companies, was that, well, what was the alternative? You couldn't pursue your case and you would have been out on the street starving, or out on the street with no other choice but to do what you have to do to feed yourself and your family, which is, unfortunately, people are put in situations where you have no other choice but to steal meat from a grocery store. In essence, go back to a life of crime. But, this is what I'm just reading in between the lines, not even knowing the full side of the story. But, I really want people to understand there's going to be another side to this. And I'm totally speculating, but
right.
I can, this is standard language that both sides use in a lawsuit to make their position seem stronger or more dramatic or more dire,
Right.
more reasonable.
That's the theater I was talking about,
Because what
folks.
he's having to explain right here is, why it was reasonable for him to enter into all of these huge loans.
Right. Because he
Okay, go ahead.
believed that Kathleen Zellner was going to represent him. Right. Okay. So, although Ms. Zellner had an obligation as Mr. Boyd's representative to deal with these lending companies honestly and fairly, Ms. Zellner did not do so. In fact, Ms. Zellner kept Mr. Boyd's settlement on his medical care case a secret so that these companies would not learn about it. As Mr. Boyd learned belatedly, some or all of these lenders had the right to recover funds from this settlement. But Ms. Zellner kept it a secret and did not repay these loans when she received the settlement money on Mr. Boyd's behalf.
So this happens all the time. Is AG on? Is Adrian on in the chat? I don't see her. But okay, so this happens all the time in personal injury cases. And if you get in an automobile accident and you're taken to the hospital and you break your leg and you have, I was going to use 10,000, but that's not even realistic anymore. Broken leg probably be, especially if they put pins in it, 50 grand, hospital and doctors and everything. Well, and then you have, the other side says, well, we don't know if we're liable, and they drag it out. Well, the hospital, before they'll even let you go, they want to be paid. And so if you have medical insurance, you say, well, I have, Blue Cross Blue Shield or, Aflac, whatever you got, and they pay your bill. Your insurance company pays your bill. Then in the fine print in your insurance company, it says if a third party is responsible, i.e., let's say a negligent drunk driver that rear-ended you and broke your leg, liability's clear. You're sitting at a stoplight, minding your own business, and boom, you get whacked behind, you break your leg, they're intoxicated. And so in the fine print in your health plan, it says if a third party's responsible, the drunk driver, and you get a recovery from that third party, you will pay us back what we paid for your medical bills. And most people don't know that. Now, some companies are really, really good about it, and they let they contact the insured and say, have you filed a lawsuit? No. Are you planning on it? No. And they periodically get updates from them all the way up until the statute of limitations. But anyway, they say, yeah, I contacted an attorney. Okay, who is it? Well, it's Kathleen Zellner. Okay, and then they send a letter to Kathleen Zellner. Now, it varies state by state. In some states, they can file a lien at the courthouse, and if Zellner kept it a secret and there was a lien, Zellner or any attorney that had notice of the lien but went ahead and paid the client and not without deducting the amount of the lien, the attorney becomes personally responsible for it. Now, that's in some states. Other states, they're like, we could care less about health insurance companies trying to recoup dollars they spent when they got the premium. They made a profit.
Yeah.
Now they're trying to reduce the recovery of their insured. Well, anyway, so some don't provide for a lien, and so what they do, and this is common. The only statutory lien is what we call it. The only statutory lien in Texas is a state, county, governmental run hospital. They can run down for the amount of medical bills, and they can go file at the county courthouse a statutory lien. And you have to check that if you're representing somebody that there's no statutory lien filed. And sometimes it's a race to get a case settled before they file that lien, because if they file that lien and it's $1 million in medical bills and the other side only has $100,000 in insurance, you're not going to get any recovery whatsoever. The $100,000, instead of going to you, is going to go to the hospital. But other than that, so if a health insurance company sends you a notice, hey, we're so-and-so's healthcare company, Blue Cross Blue Shield, we have a $50,000, we've paid $50,000 in bills. They said, you're the attorney. Can you please keep us up to date? This happens all the time, what I'm going to tell you right now. So let's say there's only $25,000 in insurance. That's the minimum that you're required to carry in Texas. Some states it's 15, some it's 50. Texas it's 25. And they have a minimum limits policy. This is why everybody out there should have the most uninsured motorist coverage you can get. If you can buy $1 million, buy $1 million. It's super cheap. But if they only limit you to what you have in liability coverage, buy the max, because this is where that coverage would help somebody. But the other side only has 25. And so people tell them all the time, look, there's your insurance company has paid medical bills, and they're sniffing around. I'm going to go ahead and give you the full settlement. It's yours. There's no law that prevents me from paying you the full amount, but you need to be aware, and this is part of papering your file. You need to be aware that they could come after you for that money. Now, so we have two options. I can try and negotiate their lien down to something like 5 or 10,000, see if they'll take that, and then you would get the difference. If I can get them from 50 down to 10, you would get 15. Let's ignore the attorney's fees right now. Or you can just risk it. I'll pay you the 25, and you understand that they may file a lawsuit against you. But we paper the file, and whatever choice they say, we say, you understand they may come after you for this.
Right.
And
you have a record of that acknowledgement
we've explained this to you, so on and so forth. So that's what that is talking about there. And I don't know what the law is on it in Chicago. Usually it's pretty bad for the client that if there's no legal obligation, like a statutory lien, to pay those loan companies, because what they're saying is they're so unsophisticated. It was so confusing. It's not. It's basically, look, we're going to loan you up to $500,000. You don't have to pay us back until you settle. When you settle, you pay us back.
Right.
Has nothing to do with the attorney. All they do is they send notice to the attorney, look, your client has signed this agreement, but we represent the client. And so, we don't have any duties, lending companies. And, sometimes their decision, look, I could try and negotiate with these loan companies, see if they'll take less interest or something, so on and so forth. We didn't get a full recovery on the lawsuit that we thought. So maybe instead of 476,000, they'll take 400. But if the attorney instructs us, I don't want you paying them, we can't do it. That money goes in trust. It's not our money. It's the client's money. We deduct the attorney fees that are agreed upon. We deduct the cost. Those are agreed upon. And then it's like, now I don't know how well she did at papering it or not.
Right.
From just what I saw in Making a Murderer and how meticulous she is, and that she conferred with
this stuff documented, right?
Yeah, and that they are very experienced in the personal injury game. My guess is she's papered it.
Right. Okay. So at some point, discovery ended in Mr. Boyd's federal civil rights lawsuit. On July 11th of 2016, the defendants to the wrongful conviction case filed a motion for summary judgment on Mr. Boyd's claims, presenting along with their motion numerous purported statements of material fact reflecting facts, in their view, developed during the litigation that showed they were entitled to summary judgment. Ms. Zellner, in responding to this motion, failed to marshal the relevant facts developed during the litigation. This compounded the problem of Ms. Zellner not having developed all available evidence during discovery that would have allowed Mr. Boyd to overcome this motion. On December 6th of 2016, the federal district court granted summary judgment for all of the defendants, resulting in Mr. Boyd's case being dismissed in its entirety. Applying the appropriate standard of diligence, any reasonably competent, experienced civil rights attorney should have been able to overcome summary judgment in a case as strong as Mr. Boyd's was. So Mr. Boyd feels he has a strong case. Obviously, Ms. Zellner feels that he didn't. Mr. Boyd and his family were devastated by the dismissal of his lawsuit, particularly after Ms. Zellner's representations that the litigation would be successful. Ms. Zellner promised to appeal and told Mr. Boyd she was confident in the outcome. The appeal was filed before the Seventh Circuit as appeal number 17-1018. During the pendency of the appeal, Mr. Boyd became concerned about whether Miss Zellner was serious about litigating the case and requested multiple times to meet with Miss Zellner to discuss the case. Miss Zellner in her office told Mr. Boyd multiple times that they could not meet with Mr. Boyd until later in the appellate litigation. The Seventh Circuit appeal was ultimately fully
What
briefed.
that is, number 34, that's typically where clients want money, and it happens all the time.
Okay.
And Zellner's had a case where that happened, where the guy demanded to meet with her and said, "Look, if you don't pay me $8,000, I'm going to take my case elsewhere, and I'm going to hurt the other people's cases." And what did Zellner do? So she went straight down to the police department and swore out a complaint for blackmail, coercion against her client, and said,
Mhm.
it was nice knowing you. See you later. And then you saw how much that guy backpedaled. But you're dealing with people that been falsely imprisoned in an institutional
They
atmosphere.
don't have much money.
They're
Right.
surrounded by other clients, and one of the oldest prison gang scams that gets run is, you find out about somebody, you find out what family they have, and then you start to make threats against this person. Look, unless your family starts sending 500 a month, 1,000 a month, we're gonna have our friends on the outside kill your kid. We're gonna have our friends on the outside, break your wife's leg, and they'll send people to the house, kill animals, and so this man was in prison for 28 years. So he saw, is that right? 28 years for an exoneration? 28?
It was
Mr.
over
Boyd?
20. I thought it was
Yeah.
21.
Or
But
21. Okay, 20 plus years in prison. He's seen everything. And so unfortunately, that, he's 52. All right. So he goes in at 32. And, for the last 20 years, that's all he knows is literally dog eat dog and extortion and, trading cigarettes and all of it.
yeah.
And protection. And when that's all then you end up with clients like the one that approached Zellner and threatened her that if she didn't pay him 6,000 or 7,000, and we even saw it with Stevie in a different way. Stevie, according to the sexual assault victim in the first case, she said that, one time, all of a sudden, Stephen and I reconnected as part of the legislation that they were going to pass to compensate wrongfully convicted people in Wisconsin. They met and he forgave her and, or nothing to forgive, I think she said. He was very gracious, and they started up a loose connection. And then she said that lasted until all of a sudden I got a phone call from Stephen, and he said, "Hey, I'd really like to get out of Wisconsin, buy a house and get out of here." And she's kind of like, "Okay, yeah, I could see why you'd want to do that." And then he's like, "Well, you think you can help me out?" And then she said, you all remember it, are you asking me to buy you a house? And he's like, but understand, that's their thinking. This woman had, you know, a successful, to some degree, confectionery or candy store in Manitowoc, but and so you just being out of, you know, normal day-to-day life and, you know, working, earning a wage, you know, knowing what a loaf of bread costs, a gallon of gas, et cetera, et cetera, et cetera. You assume, oh, well, she's got a candy store on Main Avenue. She can buy me a house in Minnesota.
Mm-hmm. Right.
And so, but it's, these people aren't to, you know, blame for that when you're in that type of society, when you're, you know, have those types of surroundings. Shawshank Redemption, man, I mean, Stephen King, such a beautiful writer. You know, they talked about the guy that got out and he was struggling, and, you know, he used the term, he's institutionalized. And I don't know of a better term for it, but these people become institutionalized, and so they don't do things, they don't think like a regular person in free society does. They, you know, their whole perspective just becomes warped. You know, it's but you know, so going back to this paragraph, what they're describing is, you know, it's very, very common just in regular personal injury litigation. People come into you and say, look, you know, I'm going to need $5,000 right now, or I'm going to pull my case from you. And, you know, you might have a lot invested in it, and it's, you know,
Right.
I was never really big on making loans to clients other than true litigation costs,
Right.
experts, filing fees, photocopies, et cetera,
Right. Right.
because, you know, at some point, the loan amounts, and that varies state by state. Some states you're allowed as a lawyer to loan a client money, others not.
Mm-hmm.
Texas, you can loan money. Nevada, you can. California, it's extremely limited. That's why these loan companies popped up. Attorney can't do it, but a loan company can. Um,
Right.
but that's one of the reasons some states don't allow it, is that at, at some point when you have so much of your money, the attorney's money invested in a case, you're no longer objective. So when an offer comes in that may truly be low,
Mm-hmm.
because you have so much money invested in it, you may be tempted to try to recommend that settlement offer. Whereas if you had no money invested in it, you'd tell your client, hey, you know, I think it's low. I think we should keep pushing towards trial. But you know, there's really very, very, very little to meet about in an appeal. Uh, you don't need to go over facts. You know, the facts are locked in from the trial. Um, you know, pursuing investigation and whatnot. I have no idea what, you know, the underlying case was, or, you know, if she could, but appealing a granting of a motion for summary judgment, there's really not much you need to meet with your client about. Now, you have an ethical duty to to have reasonable communication with your
Mm-hmm.
client and to keep them, quote, reasonably informed, unquote. And I'm
Mm-hmm.
sure they did that. And I'm sure, you know, requested multiple times to meet with Zellner to discuss the case. Well, the state bar doesn't require you to meet with a client every time they call up and want an appointment. You know, I'm just sorry. It's, you know, Mr.
Right.
Boyd, I told you, you know, our brief is due on such and such a date. You know, we we may need to get an extension on that. I'll let you know.
Right.
You keep them reasonably informed. But that's what I think 34 is about, reading between the lines.
Right. Okay.
What's your take on it? All right, you know.
Hold on, let me put it back up.
It just basically says she requested multiple times to meet with Zellner during the
Right. So yeah, my
case.
thought is that he was trying to get information and she was shining him on. I mean, at least that's his claim.
And so number 34 is going to be one of those allegations that's very easy. You know, it's either going to be a major problem for Zellner,
or
which
she's
I
going to
doubt,
easily prove that she was keeping him informed. Right.
like, and we go back to, you know, you paper your file,
Right.
your file.
Exactly.
And,
Which would make it easy for her to prove she had met her obligation. So
and I suspect she CCs carbon copy. And when I started practicing law, there actually were carbon copies.
right.
Now it's technically an EC. I bet she carbon copies her client on everything.
Right.
And if that's the case, 34 is out.
Yeah, but I don't know. I mean, the part of the reason why you hire an attorney is to help you understand, right? So
Well, yeah, you know, and that's two things, but that's why the state bar says reasonably informed. You know, when your upcoming court dates are, you have an absolute right to know when your upcoming court dates are, when, you know, what's the next step in the litigation. But, you know, unfortunately, you know, I mean, just look, for example, at these conversations, you know, Catherine, and I realize all of that stuff in MAM2 was staged for the purposes of the producers. I'm not naive. I've been in documentaries in the courthouse in Austin that documentarians followed, and you know, I know how these things get staged. I've been personally asked to, hey, we missed the shot. Would you mind going back into the courtroom and standing in front of the podium, and we get a shot of you? And you know, you participate in stuff to make it look more real time, but it, you know, it's staged. And anybody who's a fan of the, you know, Housewives of New Jersey, Housewives of Dallas, you know when some of that stuff is staged. You can just tell it. You know, the cuts are obvious. They're wearing different stuff and whatever. But anyway, so but some, you know, Barb talking about, you know, where things are, and describing her, you know, Nyrider and the, you know, that team, and giving their take. They're sitting on the bench, her and Scott, and and then sitting around the coffee table, not coffee table, the little dining room table in the kitchen at Ma and Pa's, and she brings in the brief, and Pa starts thumbing through it. And I think Pa, if you spent long enough, would fully understand it. But Ma, you know, not so much. She's, you know, Catherine Zellner sat down, and Ma asked the question that criminal defense attorneys always get. You know, you file the first thing, and you know, and they always ask it, especially moms. God bless them. You know, when's he going to be getting out? And she says, soon. You know, he'll get out. You know, the case is X number of days old. The first set of attorneys were on it over X number of days. I've been on it Y number of days. You all remember the scene.
Mhm.
And, you know, an attorney, so let's just pretend the Averys, for whatever reason, decided to sue Kathleen Zellner.
Yeah.
I think the chances of that happening are about as much as this lawsuit going anywhere. But they, you know, people could write that down that, you know, she gave them a false expectation of success because she, you know, is trying to reassure the client's mom. Number one, those aren't even her clients. Stephen is her only client.
Right.
Number two, she's telling a mom he will get out. Eventually, he will get out. And then she makes the analogy about a foundation. And first, you have to chip away the foundation, and then it all falls. And she says, I've answered every question, I've answered every piece of evidence. And, so an attorney, you know, seeing that, and you saw how it was worded in Colburn's complaint that, you know, the way this was done, you know, it was clearly this or clearly that. Well, yeah, that's their job, to paint a picture as favorable to their client as possible. But, you know, in reality, it's different. You know, in reality that there's a dispatch call where Colburn's calling in the numbers. And, you know, people can draw their own conclusion. Was he looking at the car and reading the license plate number when he called that in? Or is that the diligent Sergeant Colburn calls in every missing person license plate that he gets to confirm that the information he received from another law enforcement officer was accurate?
Right.
People can make their own conclusion, but this is a complaint for damages, and so it's spun entirely in favor of the plaintiff, just like a probable cause affidavit in support of a search warrant. So if anybody's read the search warrant affidavits in the Stephen Avery case, and I know there's a lot of them, but you see it's like all one-sided, which they can be. You know, the defendant doesn't get an opportunity on a search warrant to come in and give rebuttal. It's just, hey, the detective fills it out, shows it to the judge, and says, this is why I think probable cause. We found a car there, we found blood in the car, we found this, we found that. But they're not required to mention, by the way, we found bones in the property next door, but we don't think they're human. They're not required to put that in. So I want people to understand this is one half of the coin, and then there's going to be a whole nother half. Okay, go ahead. Sorry.
Okay, so Seventh Circuit appeal was ultimately fully briefed, and on January 4th of 2018, the case was set for oral argument on February 14th of 2018. This date presented a personal conflict for Ms. Zellner. Although she had taken on the obligation to litigate this case for Mr. Boyd, she did not want to interrupt her personal plans to be present for the oral argument. The Seventh Circuit has rules requiring attorneys with scheduling conflicts to apprise the court in advance of the dates that they are going to be unavailable for oral arguments. Ms. Zellner ignored those rules, waited until the date had been set, and then filed a motion with the Seventh Circuit reflecting that she had an out-of-state vacation planned with her family from February 6th through February 20th of 2018 and asked for the oral argument to be postponed. Not surprisingly, given that she had failed to comply with the court's rules and procedures, the Seventh Circuit denied Ms. Zellner's request to move oral argument. At this point, Ms. Zellner had numerous options, including moving her vacation, traveling back during her vacation for oral arguments, retaining another attorney to conduct oral argument on her behalf, or simply telling Mr. Boyd that she could not keep her obligations and giving him the option to find other counsel who could present argument on that date. Ms. Zellner chose to do none of these things. Instead, she decided to voluntarily dismiss Mr. Boyd's appeal, effectively terminating his entire wrongful conviction lawsuit. To that end, even though the appeal was fully briefed and ready for argument, she filed a motion with the Seventh Circuit dismissing the case shortly before oral argument. She then lied in discussing what had occurred with Mr. Boyd, telling him that it would be preferable to take this case to the state court, claiming for statute of limitations reasons that the case had to be pursued in state court to avoid a bad ruling from the Seventh Circuit.
Okay,
She assured him.
Hang on. Jamie, no, it's an adversarial system where you have advocates on either side arguing vigorously on their client's behalf, constrained by not, committing perjury, not manufacturing evidence, not tampering, bribing a juror. So no, it's not more of a game than a process. It's a process. However, their successful attorneys are very familiar with the process, and they know how to maximize the process on behalf of their clients. And the one equation that's left out of all of this is that you have a supposedly, hopefully, neutral person that is judging the game. So yeah, it is like a game in a tennis match. You have the umpire up in the chair, you have linesmen all over. They're calling balls in, out. They've eventually gone to mechanical optical systems to avoid human error, but it's an adversarial system that have humans throughout it. And so it's not a game, it's a process, but there are certainly people who are better at maximizing, optimizing the process on behalf of their client. Everybody will tell you is that the system works the best when you have well-prepared attorneys. Mm-hmm. And they know their cases. They put in the time and the effort. There's hardly even an objection because we know the cases so well that the other side may try to sneak by one or two things just to see what they can get away with. But they learn no one likes to have an objection sustained in front of a jury. So it's definitely theater, right. But it's the highest form of theater. Especially in the criminal arena, you're dealing with somebody's life and liberty. Mm-hmm. But right. I think that's a legitimate question you had, Jamie, and so I wanted to pause to answer that. Okay. No, I don't think it's more of a game. It definitely is a process. You have to have an attorney that knows the process. And then, in my opinion, what we've seen with Zellner is not only is she familiar with the process and whatnot, is that in terms of developing evidence, I haven't seen anybody like her use scientific evidence to find answers in a case where other good seasoned lawyers weren't able to. And you do learn a lot of stuff doing medical malpractice. You're constantly dealing with experts, and right. Whereas some attorneys don't get that much experience with experts. But okay, go ahead.
Right. Okay. She assured him that she could obtain relief for him from the state court. She promised to file a lawsuit on his behalf in the Circuit Court of Cook County, asserting that Richard Zuley had intentionally inflicted emotional distress upon him. Ms. Zellner filed the state court lawsuit in August of 2018, knowing that the statute of limitations on such claims is 2 years and that the litigation had no chance of succeeding given that it was filed beyond those time limits. Ms. Zellner.
Okay, that's bad for Zellner right there, if that's true.
If it's true, right.
But if she hasn't papered the file, the fact that the statute of limitations is what we call an affirmative defense. So sometimes we'll tell a client they've come in after the statute of limitations has expired.
Right.
That their automobile accident was January 1, 2016. They come into my office January 5th, 2018. Hey, I'm sorry to tell you this, but there's a 2-year statute of limitations. California is 1 year, by the way. Mm-hmm. And against certain municipalities and governmental entities, you have to file a claim within 6 months. A claim, not a lawsuit. But so you have to check this isn't legal advice for the whole country or the whole world. I'm just telling you, every state has statute of limitations. They vary state to state. Yet you need to know if you've been injured or have some sort of a claim, what the statute of limitation is in your area. So seek professional legal advice if that's your situation. But as an example, if you were in an auto accident in January 1 of 2016, you came into my office January 5th, 2018. I really don't do personal injury, but just as an example, I'd say, I'm sorry to tell you the statute of limitations expired 4 days ago. You have no case.
Right.
Well, but there's a few exceptions. Are you in the military? And maybe we can use the Soldiers and Sailors Relief Act. And then we'd look at every exception that there possibly might be, and nope. A friend just told me about you, New Year's Eve at a cocktail party, and I called this morning, and you got me right in. Because personal injury firms they set up their staff to ask, when did this occur? Because they want to know, if there's a statute problem. Mm-hmm. It happened 1.5 years ago. Okay, we want you in next week. It happened, a year, 11 months, 3 weeks, and 4 days ago. We want you in here this afternoon. But sometimes we tell them, okay, look, it's an affirmative defense. What's that mean? What that means is we'll file a complaint. They have to file an answer. If they don't set out in writing the affirmative defense of statute of limitations, it's waived. Okay. We'll see if they waive it. And we paper that. We say, look, the statute of limitations is expired. You came in too late. You met with me on this date and time. We're going to get a lawsuit filed tomorrow. And, but you need to understand, if they come back with the affirmative defense statute of limitations, we are going to dismiss our case. So, if this isn't papered in some way, right, she's going to have trouble.
So basically Zellner, and most likely knowing Zellner, she has this all documented and is covering her booty, so to speak. So at least that's her MO usually. So it's going to be interesting to see Zellner's response to all this is basically what I'm getting at.
I didn't know she filed the lawsuit in August of 2018. I somehow missed this when I was reading it.
Oh,
and
okay.
I knew that they were claiming that. I guess one possibility is this attorney is just full of it, but that would be a pretty bold statement,
right,
even in Amsterdam, to say, because everything's file stamp that's filed,
Yeah.
and so why would you make something up like this? And this
Unless
is
it was
something.
true, right.
this is something that you wouldn't rely on the client just to tell you. Oh, so she filed, but it's interesting that he doesn't put an exact day.
August, yeah.
August 17th, 2018, because it will have a file stamp on it.
Right.
Look right to the left of, where you're at. It's horizontal. It's a vertical.
Yes.
File date 12/27/2018 at 11:33 a.m. They have an e-filing system, obviously, and it timestamps stuff. But it's interesting.
Yeah. So Ms. Zellner filed with the state. Let's see. Ms. Zellner also knew, or should have known, that if she was even minimally competent to practice law in the subject area, that her previous loss on all claims in federal court effectively foreclosed any and all relief in state court, and that Mr. Boyd's only chance of recovery was to proceed with his appeal. Since that would be true, correct? Just a yes or no answer.
Yes.
That would have been his only way forward. That he's saying that she would have canceled here. Right. Okay. Since the filing of this lawsuit, Mr. Boyd attempted multiple times to contact Ms. Zellner about its status and make sure that the litigation is moving as Ms. Zellner promised. Ms. Zellner has failed to return any of his calls and has never been available to talk to him when he has called. Thereafter, on December 5th of 2018, Ms. Zellner wrote Mr. Boyd a letter on behalf of herself and her law firm informing him that she had voluntarily non-suited his lawsuit. Ms. Zellner's letter attempted to blame Mr. Boyd's flawed testimony for the fact that the federal lawsuit was unsuccessful. What does non-suited mean?
Dismissed.
Okay. Ms. Zellner's letter further stated that we were forced to repay a loan you took out and reneged on payment, and claimed that Mr. Boyd owed further money to an individual who she retained to provide legal services. Regarding the former issue, during the summer of 2017, while Mr. Boyd's federal appeal was pending, Ms. Zellner contacted Mr. Boyd and told him there was a problem with one of the loan companies that he had been taking a loan from, and that one of the loan companies was suing her. She asked him to take his money out of the bank and put his money into properties in the names of other people because he might be a target for these lending companies for not repaying the loans.
Stop. Okay, so that could just be solid legal advice, as long as you're not advising somebody to break the law. And so during the first bad recession in the 80s, and then in the bust of 2008, attorneys tell people, hey, it looks like we're heading for bankruptcy. They'll tell them, okay, look, pick up everything, sell it, and move to Texas or Florida. Why? Because
those states protect, right?
We have unlimited homestead, and they tell them buy the most expensive house you can afford. So you sell everything, you sell your $500,000 house, you sell everything, you take your $900,000 and you buy a $900,000 house. Well, we have an unlimited homestead in Texas and the same in Florida, and they could never get that house. And it's protected forever. We're a haven for judgment debtors. That's people who have judgments against them. There's nothing. If assuming what she advised is not illegal, there are doctors who pay tens of thousands of dollars for asset protection to set up an offshore corporation. Half this stuff isn't even legitimate, but they're paying tens of thousands of dollars and opening accounts in the Caymans, so that, if they got a judgment that exceeded their malpractice limit, they got a $10 million judgment, but they only have a $5 million policy, that their assets are protected. And so, and this jumps out of chronology. I'm just, he's trying to bend this on Boyd's behalf. It's about this loan thing, but it begs the question, Mr. Boyd, did you sign that loan? Did you sign the loan agreement?
Right.
You see this part right here? It says, I've had the opportunity to read. I've read every paragraph. I've initialed every paragraph. And I understand the terms of the loans. I don't know if these companies are subject to truth in lending, but anybody who's ever bought a house or a car, you get that truth in lending statement. You're going to have X number of payments. The interest rate is this. You really don't have much of a leg to stand on when because the law is set up to protect big banks and big loan companies and credit card companies. We as the consumers keep losing out on that. But so 47, it's not too impressed by that.
Okay. Ms. Zellner also asked Mr. Boyd for $100,000 and represented that she needed this money to take care of financial matters for Mr. Boyd. This representation was false. She repeatedly asked Mr. Boyd for funds. Ultimately, Mr. Boyd gave her $40,000 on her promise that she would repay him. Wait a second, Mr. Boyd.
No idea. If that's true.
Told you that you reneged on a payment and she had to pay one of your debtors. I mean,
if that's
me putting
true,
2 and 2 together here, she was trying to recoup her losses for paying because you couldn't make your payments. That's what it sounds like to me. But anyway,
I don't know. But the way he's phrased it is, you owe 100,000, Mr. Boyd. I could easily see, you owe 400,000. I can settle this for 100,000 for you. But that somehow he didn't owe 400,000. She repeatedly asked him for the funds. Ultimately, now, of course, he doesn't say what the time period is, so we don't know.
right?
The paragraph above it,
right? Yeah.
Paragraph above it, where it's summer of 2017. The paragraph above that, we're December 5th. He's jumping all around, and I think it's on purpose so that you can't, and we'll talk after we get through this. Maybe somebody's funding this. I don't know. Is the city attorney for Manitowoc, is he buddies with this attorney, or maybe they approached Boyd's wife and said, hey, we got a guy that'll sue Zellner for you.
Right.
We know as much about that as we do about so many things, but that's just bizarre. I mean, if ultimately Mr. Boyd gave her $40,000 on her promise that she would repay him.
I'd like to see proof of that promise.
That, it sounds like convict talk to me, but but it could be. It could be a misunderstanding. I doubt there's going to be paper on that from either side. It's going to be a he said, she said, and then it's then it's a matter of what makes sense. How do the dots connect? Okay, number 49, I think.
Right. Yeah. Miss Zellner then embarked on a months-long campaign of failing to return Mr. Boyd's money. Mr. Boyd repeatedly asked for the return of his funds, and Miss Zellner repeatedly promised but did not repay him. At least one check that Miss Zellner provided to Mr. Boyd did not clear. Another check was $18,000 short, In total, Ms. Zellner provided the money to Mr. Boyd a few thousand at a time over multiple months. It took her almost a year to return these funds to him despite repeated requests for payment.
So, that sounds like there'd be a clear paper trail. If you bounce a check out of a trust account, okay, so there's two types of accounts that attorneys have. We have our general account. We pay our employees from that. We pay ourselves out of that. We pay for our big fancy Cadillacs out of that. We pay for our drivers to drive us to Wisconsin out of that. We pay for rent if we're leasing a big nice building. We pay mortgage company if we bought our own building, just like any business account anybody would have. And then we also have a trust account. Sometimes it's called an IOLTA, IOLOTA trust account. It earns interest, but that interest we don't even get to keep. It goes to a fund for indigent defendants to fund the indigent. And it also funds, if an attorney steals money from a client, they've left the country or they've died, it funds a client money recovery fund. But anyway, that trust account, we cannot commingle our money with our client's money. And so that belongs to the client. It may be a deposit for a piece of real estate. We're handling a real estate transaction. It may be the settlement proceeds, $100,000 for settling a personal injury case, 40,000 attorney's fees. We can withdraw that, but 60,000's got to remain in that trust account. We cannot commingle our money, the money with it. We cannot say, oh, well, I'm going to borrow 5,000 of that 60 to pay for the health insurance for my employees because I know I have a case settling next week. I've got a check coming in. It's totally illegal. It's illegal, one. Number two, if you bounce a check on your trust account, it's going to create an instant bar complaint. And unless you have a really good explanation for it, at a minimum, you're going to get publicly reprimanded. In case anybody's wondering, I've never had a bar complaint. I've never had any type of disciplinary in any state or federal jurisdiction I've practiced in. I've had clients complain, but I meet with them and we work it out. Right. Everybody in business has people that may not be happy, but you do what you need to do to resolve it. But if you bounce a check on a trust account, a lot of states, the bank's required to notify the state bar, and it is all kinds of problems. They're not alleging the trust account, so I'm taking it's the general account, but this sounds like there's commingling of funds. What they're alleging, I'm not saying it happened. These would be serious bar concerns.
Okay. All right. As a result of Ms. Zellner and her office's complete abdication of their professional responsibilities to Mr. Boyd has been irreparably damaged. Mr. Boyd lost the opportunity to seek a settlement or verdict on his federal civil rights litigation that would be worth upwards of tens of millions of dollars. Other individuals with lawsuits no less meritorious than Mr. Boyd have recovered more than $20 million for their comparable injuries. Moreover, Mr. Boyd was induced to take on hundreds of thousands of dollars in loans to take other financial steps in expectation of recovering money in his civil rights litigation. As a result of the defendant's conduct, Mr. Boyd suffered the above described financial losses, as well as anxiety, fear, depression, and stress. Count 1, malpractice. As described more fully above, Kathleen Zellner and the law offices of Kathleen T. Zellner Associates formed an attorney-client attorney-client relationship with Letheriel Boyd, in which they promised to represent him throughout the proceedings of both his wrongful conviction litigation and his federal civil rights denial of medical care case, and promised to represent and advise him in assisting him to obtain financing to help him during the pendency of his litigation. Defendants owed Letheriel Boyd a duty of care arising from the attorney-client relationship. Kathleen Zellner and the law offices of Kathleen Zellner and Associates breached their duties toward Letheriel Boyd. As a result of the defendant's conduct, Letheriel Boyd's federal civil rights litigation was voluntarily dismissed. As a result of the defendant's conduct in dismissing
the number 57 isn't really true. The full they've skipped over that he lost a motion for summary judgment. It's interesting that up above they talked about that she didn't do a good job trying to fight the motion for summary judgment. Now they're saying it voluntarily dismissed, but we'll talk about causation in a minute.
She dismissed his appeal with the Seventh Circuit. We can't deny that, right? She dismissed it.
Yeah, that's true. But you first, it's what comes first is, do you even have a case? But we'll talk about that in a minute after we get through this cause of action. But they don't put in there that she fell below the standard of care in opposing the motion for summary judgment. That's a problem for the plaintiff.
Okay. Where are we at?
Because here's why that's important. If you got a dead bang loser of a case, let's say it's the example, somebody didn't come in time and the statute of limitations was blown. And I said, okay, I'm going to file a complaint for you anyway, and we'll hope for the best, and we'll hope that they don't allege the affirmative defense in their answer of statute of limitations. And then they allege statute of limitations. And I said, well, there's this one case I found from 1847. It's thin, Erekose, but I feel bad the way that Scooby-Doo harmed you and collided with your dune buggy, and so I'm gonna try and get past the statute of limitation.
Dang it, Scooby!
And then Scooby files a motion for summary judgment. Says, hey, the accident happened January 1st. Here's his complaint. Wasn't filed till January 5th. Erekose should not recover, Judge. And we file a response, and I do my best, and I cite my 1847 case, and the judge says, sorry, 1847 case just doesn't cut it. Here's statute says you got to file within 2 years. It's more than 2 years. And you haven't met any of the exceptions. Case dismissed. And then I tell Erekose, I really, really, really don't like Scooby, and I really liked your doom buggy she crashed into. I'm going to appeal to the Seventh Circuit. We don't have any chance in the Seventh Circuit, but maybe, we can maybe get a nominal settlement value.
So this sounds to me, Travis, like you're saying this is basically just going to be Letheriel Boyd's word.
Let me finish the example. So and so it's like everything turns sour in the appeal and nothing is panning out. Now you really have to advise your client before you're going to dismiss an appeal. And I'm assuming she papered that in some way, but going back to you dismissed the appeal. You got to go back. If there was never a case to begin with, and that's why summary judgment is granted,
Mhm.
There are zero damages from dismissing the appeal. You follow what my thinking
Oh, I
is
see
here?
what you're saying.
It's,
Okay.
I told you on January 5th, you're out of luck, but I'm going to do
Yep,
this,
she did that. Yes.
try and help you. And
So,
it
like I
didn't,
said, go ahead.
and it didn't pan out. And
Right.
then it's like, okay, well, I've gone through this process or game long enough. Now, I would call the client and say, look, they're not going to offer a dime. They've called our bluff. I'm going to dump it. Okay, Mr. Williamson, you told me that from the beginning. I said, you're going to be getting a letter from me confirming that you have no objection to me dismissing the appeal. I'm going to send it to you, and it's going to say, if you have a different recollection, contact me immediately.
Mm-hmm.
I'm going to send you that letter certified. I'm going to wait 5 days, and I'm going to file the dismissal. And I've papered my file. But let's say one day I forgot to call you. I was having a bad day. I confused the Erekose case from the Shaggy case. And I just screwed up. I messed up and I didn't call you, and I dismissed the case without your permission or knowledge. It doesn't matter. I owe you nothing, not a dime, because your case was, you never had a case to start with. Your case was thrown out on a summary judgment motion by the trial court. It's worth zero.
Right.
That's
Two things
why
I
I
have to say
say
about that.
that's a
Number one,
problem.
okay. Number one, if your scenario has to assume that she has the documentation to back up that she didn't do all the things that he is asserting, in which case, yes, then she will be able to defend herself against this. But it sounds to me like what you're suggesting there, Travis, and I think I find it a little bit disturbing. What if he's right and she didn't develop his evidence properly? What if he's right and she did and she was negligent in her representation of him at the original, hearing or whatever?
Then he should have alleged it. But fortunately for him, you
Because
get
he
to
was looking
amend.
for her to then, because he lost there, he was then at least looking for her to rectify it, in the appeals. I mean, that was his lifeline to his eventual
But
judgment,
there are
right?
some
So that's the
things.
way he's looking at it, right?
Yeah, there are some things you cannot rectify, like the statute of limitations.
Right. Okay. Well,
And
the statute of limitation was an issue
there
in
are
Cook
similar
County.
things in the criminal law that you cannot rectify. And one is Brady, if you don't preserve it correctly. That may, remember where she came in in the phase of this, where she came in on Stephen Avery's case, and she's a master, even though she's locked in by the prior screw ups of other attorneys. She's a master of dancing between raindrops to still get the issue before the court, despite a rule that most would call trappings of the court, a trap. She's an expert at being able to say, no, because of what Stephen filed on his own, I'm not prevented from bringing this other claim. Because of the direct appeal counsel screwing up, I'm not prevented from developing this new evidence. But there are some things in post-conviction criminal work, just like in civil litigation, that are fatal. And so no, the appeal is not the time to fix a civil case. And if you have no case to begin with, you're not entitled to a dime. Let's say she just totally forgot to file the notice of appeal. They'd file the lawsuit And the defense would be, yeah, we forgot, we messed up, but there's three things you need to recover in a civil suit. You got to have a duty from one person to the other. So there's clearly a duty between a doctor and a patient, a lawyer and a client. When you drive a car, you have a duty to exercise due care, not injure somebody else. So you have to have a duty. Then you got to have a breach of that duty. So you failed to exercise due care when Scooby rear-ended Erekose's doom buggy. You breached the duty of care when you removed the wrong leg from a patient, or the wrong kidney, or the wrong ovary, or the wrong testicle, or the wrong eye. You've breached the duty of care if you don't file a lawsuit before the expiration of the statute of limitations when you had an opportunity. So if you met with me a year before the statute of limitations and I didn't file the lawsuit, that's a breach of the standard of care. The next thing you need is causation, and the last thing you need is damages. Causation is what we're talking about here. You've got to show that the failure to file the appeal, the failure to file the lawsuit caused you any damage. If you never had a lawsuit to begin with, if you had never had a 1983 action to begin with, you're not entitled to anything, even though I breached the duty of care to you.
Right. I accept what you say, but it
that's
sounds
a
to
big
me
concept that people don't understand because it's just not something they run into very often. But
this looks sticky to me, Travis, because it's up to her to prove he had a claim. And I guess what we need to find out is
at the trial court level.
Was she developing the evidence properly? Did she develop all the evidence that him and his prior counsel had developed? These are the questions that are ringing out in my head right now because I want to know.
And the answer to them, some of those, is in the decision granting the motion for summary judgment. Part of Mr. Boyd's problem is he lied during the case, or he was intentionally being deceptive. Mm-hmm. At one point he said, this happened, but yet in his deposition, he testified the totally opposite. You're under oath in a deposition. Mm-hmm. And then it seems to me, and I haven't read the briefs yet, Zellner was doing everything she was possibly can within the rules of ethics to slant it to her client's favor. And so it doesn't surprise me at all if there is a letter to Mr. Boyd that says, I'm sorry we dismissed this because, unfortunately, your testimony sank your case, or your untruthfulness sank your case.
He claims that only happened afterward, according to this.
Well, it's right in the decision of the motion for summary judgment. So he can claim anything he wants. We know it happened in the motion. We know it happened in discovery leading up to the motion for summary judgment. But
that she informed him about that.
Well, not the informing.
Oh, okay.
He clearly says, I wasn't informed until months after the fact. But I mean, he's all over the place talking about loans.
Yes.
And some of those there's no question, can, at least in Texas, Nevada, California, the states where I've been admitted to practice, that'll get you in hot water with the bar, commingling money. We're I can go on forever about that. What she alleges in here, it's problematical, but there's there are allegations. And like you said, at the very top, In our system in the US, anybody can sue anybody for anything. And then what we have to counteract that is the plaintiff has the burden of proof. They've got to prove the case. They can allege whatever they want in here. And, assuming it meets the technical requirements, and, that the person they've sued, really did represent them, or really was their doctor, or really was driving the Scooby Mobile,
The mystery machine.
Yeah, assuming that, then what we have to counteract that is the burden of proof, which in a civil case is preponderance of the evidence. And then in a 1983 action, it's the standard of proof is preponderance of the evidence, but the standards to recover in a 1983 action are extremely difficult because all of the people have qualified immunity. And so if they make a mistake, you cannot recover against a cop if he makes a mistake.
Right.
You have to show deliberate indifference by his employer, or you have to show an intent to deprive you of constitutional right.
Right.
So let's see what they're asking for in damages.
As a result of the defendant's conduct in dismissing the litigation in failing to properly present Mr. Boyd's claims, Mr. Boyd was unable to recover the money he would have otherwise recovered in litigation, this federal rights case. Mr. Boyd suffered actual damages as a result of the defendants breaching their duties toward him, including the value of his litigation, which is in the millions of dollars.
Okay. So that's a standard. That's all standard stuff. So there's probably a rule there that you cannot allege a dollar amount. We call that an ad danum clause. You'll see at the very end of this complaint that all they do is they sign that it's worth at least, I think it's 50,000, and that's what gives you jurisdiction of the circuit court there. If it's lower than 50,000, it goes to a different court. But you're not allowed to put, like in the Avery suit, I'm suing for $36 million, because courts have found, that's merely a publicity getter. I'm suing for $100 million because I slipped in McDonald's and I banged my knee. It's ridiculous. It's just to get, and so they say you cannot put a specific amount. So what they do, this is pretty artfully, other people with lawsuits, no less meritorious, have recovered more than 20 million. That's bullshit. There's one case in Illinois, civil rights, where I think they got anything comparable to that. It was in the last year, and that's a crazy case. We'll talk about that some other day, but it's not comparable.
It's not common for 20 million to be
not in the least. So then count one is malpractice. It's down there, and this is all standard language. Paragraph 54, they're talking about malpractice in two proceedings. That one, obviously, the federal civil rights, the wrongful conviction litigation, which is the one that was voluntarily dismissed. But interesting is also complaining about the federal civil rights denial of medical care, which she settled for what he described as a substantial amount of money up above.
Yes.
Maybe we can get the wrecking crew. That stuff's public record unless
you heard the man wrecking crew.
Let's see if there was any media coverage about. Now, sometimes, as everybody's aware, sometimes settlements are made where the amount of the settlement is not disclosed, and neither side can So that's why he used a substantial amount of money, is there's a non-disclosure agreement. Otherwise, he would have said she settled it for 10 million or 5 million or 500,000 or 50,000.
Right.
He's under a non-disclosure agreement. Gotta be. So you may run into some dead ends on that, Erekose Wrecking Crew, but let's see if there was any media coverage about the settlement of that medical malpractice civil rights case where he lost his eye. And I think if you did a search with his name, prison, loss of an eye, you might find some coverage. And then they repeat, was voluntarily dismissed. So I don't know what he's got to complain about if he recovered a substantial sum. Conversion is basically the civil form of theft. I borrow the Scooby Mobile and I never return it. I would be sued for conversion. And so they talk about that 40,000 that they mentioned above.
Yeah.
And then so conversion and sounds like they're trying to extort 40,000 out of her if she'll settle quick. He does put in an amount of excess of $20 million. Yeah, good luck. And Leonard Becker, I haven't checked him out. And then we go below to Rule 222 affidavit. That's for jurisdiction, amount in excess of 50,000. That gets him into, and he's demanded a jury trial. I guess maybe in Illinois, you can only get a jury trial in cases where the amount in controversy exceeds 50,000, because jury trial demanded. And it's probably also for jurisdiction to get you in the circuit court versus, small claims court or whatever lower court. One thing, and then I'll turn it over back to you. So the instant this got filed against Zellner, every state bar is this way. You're allowed to fully defend yourself as if a client makes a bar complaint against you or a civil complaint, the attorney-client privilege no longer applies. So now Mr. Boyd is looking down both barrels of a loaded shotgun being aimed by Kathleen Zellner.
Right. Because Zellner no longer has to be quiet about what went between them. She can now speak about it.
Well, not only that, if she pursued evidence in the exoneration that's not complimentary to Mr. Boyd or downright opposite of pointing to innocence,
right?
Inculpating evidence of his guilt, she is free to bring that out. If Mr. Boyd said, "Hey, I messed up. I robbed a store last week. I don't think they got me on video or whatnot." Attorney-client privilege does not apply. Every time she caught him in a lie, attorney-client privilege does not apply. As the case progresses along and you see in pleadings, Catherine Zellner's attorneys, I'm sure they have insurance for this.
Right.
And there may be a conflict between her firm and her personally, so there may be two law firms that come in, depending on how they got coverage for them. But, they're going to litigate. If the Wrecking Crew can look in a publication, it's online. It's called Martindale Hubble. If they could look up this attorney and screenshot the page, or I can't read it anymore. Becker, the Mr. Boyd's attorney is
Leonard S. Becker.
Yeah.
Leonard S. Becker.
Martindale Hubble, Hubbell. They usually will have a biography. If somebody in the Wrecking Crew can look at that the next day or two, we could, be able to, not always, they charge a lot of money to be listed in Martindale Hubble. And so not everybody gets in it. I'm not in it any longer because the nature of my practice is 99.9% referrals from other attorneys. So, I don't need to pay the thousands of dollars for a listing, but in personal injury, they tend to be in Martindale Hubble because that's a source for referrals from attorney to attorney. But that's what I had. I'll just bring up one thing, and we've been at this a while, and see if anybody has any questions. But one thing, I'll bring up about the in the decision. So this is, we don't need to pull it up right now. We can do it another day. Shoot, the judge didn't put, well, this judge who did this decision, I mean, I've never seen so many typos and grammatical errors in a federal court decision in my entire life. That's no exaggeration. But this is right before B, count 2, plaintiff's fabrication of evidence claim. The 2 paragraphs up from that. Here, however, the allegedly suppressed statements related directly to Bonanno's role as an eyewitness, because plaintiff's trial attorney, okay, this is the trial attorney, not Zellner, because plaintiff's trial attorney could have interviewed Bonanno regarding what she saw at the crime scene and what she said during the lineup. Her statements could have been obtained through the exercise of due diligence, citing Patrick. Quoting, a criminal defendant may not be expected to ask an alibi witness for evidence unrelated to an alibi issue, but reasonable diligence certainly entails questioning available fact witnesses regarding what they saw. So this is what we were talking about earlier, that in the Avery case, Zellner's hands are literally tied because of what Stephen filed and what the direct appeal attorneys filed. And she's doing every possible claim on behalf of her client, and she brought a Brady claim. And as part of the civil rights lawsuit, you didn't disclose what Bonanno was going to say. And they responded in the motion for summary judgment. They responded by saying, we gave you their name. Trial attorney could have interviewed that person. And so we know in part the motion for summary judgment was granted because of what happened long before
Zellner came on board, right?
And then I've highlighted under B, count 2, that first paragraph. Plaintiff alleges the defendant officers fabricated the following evidence: witnesses, identification, witness statements, stories, police reports, and physical evidence. Then down below, quoting the Whitlock case, the judge that granted the motion for summary judgment. On the other hand, where a section 1983 plaintiff seeks to bring a due process claim based upon allegations that police coerced statements from witnesses, The plaintiff is actually bringing a malicious prosecution claim. And why? So that begs the question, why didn't Kathleen Zellner file a malicious prosecution claim? Well, I'll tell you why, because they have unlimited immunity. There's no case against a prosecutor. So you try and fashion it as a 1983 action against police. And you do the best you can. And so a lawyer that knows the law, reading that decision, knows that, unfortunately for Mr. Boyd, he had problems in this case from the get-go. And I wouldn't be surprised if, knowledgeable legal analysts who have read the briefs, both for the motion for summary judgment and the briefs that were filed on appeal, are going to say, the vast majority of them are going to say, she had an uphill battle from the beginning.
Right. Well, that's what what will obviously be coming.
However, commingling money with the client, if that's true, saying, give me 100,000, I'm going to pay you 40 back. Not advising your client before you dismiss an appeal. It may not be legal malpractice. It may not be any damages associated with it. It's certainly in teaching a new lawyer, I'd tell them, this is why you paper a file. All of those things may add up to a settlement value of the case, but like you said at the top, Erekose, I am sure Catherine Zellner's attorneys, who are paid by the insurance company, her E&O carrier, errors and omission, legal malpractice carrier, she's going to have insurance for that. And part of the coverage is they pay for a defense. Just like if your auto policy, if you're sued for being involved in an auto accident, they pay for attorney to represent you if you're sued as part of your policy. And so, I'm sure they're going to get with her and they're going to file the appropriate response.
Okay.
And
Hey,
hold on. Go ahead.
J-Man, papering a file means when you are filing something or you are having a conversation with somebody and something is being agreed to, what Travis means when he says paper the file is you are creating a record, an indisputable record that conversation, whatever it was, took place. That's what papering a file means. It means you are creating rock solid evidence that something happened so that it can't be denied later. Great
question. And I'm sorry. Lloyd, right on. Documentation. So you hear people talk in the medical field. If it's not documented, it didn't happen. And what they're saying is, and it's an exaggeration, clearly we gave him a pint of blood. Everybody knows we gave this man a pint of blood. Mm-hmm. There's the empty bottle of blood. There's a photo of the empty bottle of blood. But in the medical field, if you don't document it, it didn't happen. So you're taught as a new attorney, so you call up the other side and you say, hey, my answer is due tomorrow. I've been real busy. Can I have a 2-week extension? Sure, Trav, no problem. Not a problem at all. You're taught as a young attorney, you immediately send a letter to the other attorney saying, this is to confirm our telephone conversation of January 5th, 2019, wherein you graciously granted me an extension to file my answer from January 5th, whatever 2 weeks from now is, let's see, it's the 19th, to January 19th. Thank you for your continued courtesy and cooperation. Can you tell I've done this letter about 10,000 times? You're taught. You paper the file, you document the file. Excellent question. For just these type of things. So, that there's miscommunications with the other side. It's like, well, look, if you look at my letter of January 5, I confirmed the conversation. Oh, I'm sorry. I was thinking of another case we have together. No problem. It's cool. But that's why you document your file. J-Man, billion-dollar advice. Well, in some cases, the documentation has swung a civil case in the billion-dollar range, or certainly in the tens of millions.
Right. T1, the worst case scenario for Stephen Avery is he sits in prison for the rest of his life. That would be the worst case scenario.
God, that was a buzzkill.
Sorry, he asked.
Oh, God,
As far as
oh man, where did that come from? I'm
T1 is
kidding. I'm
asking.
kidding.
Hello.
Hey,
T1 is asking.
I don't believe, I believe, everybody, if people want to know the current status of Brendan and Stevie, you've certainly come to the right place for it. And I don't mean to belittle anybody trying to find out what their current status is,
Right.
but it just, my heart sinks. Your answer was absolutely correct, Erekose.
Yeah. And then the other thing is she's looking at possibly $20 million on this, but as you can tell, Travis doesn't think he has much of a case.
Well,
or that there's a good chance he doesn't have much of a case.
Well, based on what I've seen so far, I mean, if Mr. Boyd and his counsel have documents to back up his claims,
right.
I'm going to totally reassess if I'm not giving an opinion about the merits of Mr. Boyd's case. What I've simply tried to show for the last hour and a half, 2 hours, whatever it's been, I've just tried to show that there's with every lawsuit, there's two sides of the story.
Right.
And I'm trying to anticipate what the other side of the coin might be, while pointing out that, if things are true, it would be problematical. But now I want to take 1 minute to explain how hard it is to recover in a legal malpractice case. So we've talked about duty, breach, causation, damages. Every first-year law student learns this in torts. Tort's not a dessert or a unsavory woman. Tort is a wrong committed by one person against the other. Comes from our old ancestors in England. All law students learn the first year of law school. You go to torts 1, second semester torts 2, contracts, criminal law, civil procedure, pretty standard first year law school, and torts is one of them. It's basically negligence and personal injury, and you learn there has to be a duty, there has to be a breach of that duty, there has to be causation of the damages and damages. So in a malpractice case, whether it's medical or legal, first you have to show the doctor or the lawyer screwed up. Okay, and then in a legal malpractice case, where you're claiming they botched a case for you like this, it's what we call a trial within a trial. So Mr. Boyd would first have to show, okay, she didn't do a good job at the motion for summary judgment, and she dismissed the appeal. She thought that she could file in the state court, and she filed it in the state court, and it got dismissed for the statute of limitations. She messed up.
Mm-hmm.
So you've gone through step 1. The second thing you've got to prove is the trial within a trial. Then Mr. Boyd has to put on a case, the exact same case he would have put on in federal court. Mm-hmm. He's going to have to call the officers. He's going to have to put it on. He's going to have to prove that there was fabrication of evidence. He's going to have to prove that he wasn't untruthful in his deposition. they've got to put on that trial within a trial, and because the jury's going to be asked, okay, assuming you find that she screwed up and dismissed the appeal or mishandled the motion for summary judgment, what would he have recovered against the city of Chicago? And the only way you can do that is put on the case that Kathleen Zellner, if she was allowed to go to trial, to jury, would have put on. And so now it's going to be by this other attorney. And so taking our example, they would put on, okay, well, what day did you come in the office? I came in January 5th. Okay. They wouldn't even get to step 2. But let's say they said, okay, you came in a month before and it didn't get filed in time. We find a breach of the duty of the standard of care. Now let's take a look at your case. What happened? Well, I was driving down the road in the Scooby Mobile, and I was texting Erekose, and he
hit me.
he said he was starting a video, and so I turned on his video, and I was driving down the road watching his really cool video because he had this really interesting guest, Travis, and he was explaining a lot to us, and then all of a sudden, I caught out of the corner of my eye Scooby, and if she was a president, she would be Abraham Lincoln. But I saw Abraham Lincoln, and then I didn't see this car stopped at the red light, and I rear-ended that car going 40 miles an hour. Okay, what? And why are you suing the car stopped at the red light? Well, if they weren't there, I wouldn't have run into them while I was watching my program. But we all know it's not, if you rear end a stationary vehicle, you're pretty much liable. We all know that.
Right.
And so phase 2, they would totally lose. It's like, yeah, Mr. Williamson totally screwed up. He didn't file your lawsuit in time. He messed up, but you failed to show any causation. So it'll be a trial within a trial. It's extremely tough to recover in a 1983 action to begin with. Mm-hmm. So it's going to be just as extremely tough for Mr. Boyd to prove, if this case went to trial, that had Ms. Zellner done something that she didn't do, or didn't do something, or did something that she failed to do, it's going to be difficult for them to show that, this case was worth tens of millions of dollars.
Right. Falcon saying Casey telling the client that to go with her firm and giving assurances that it would be successful. She encouraged him to secure the funding for this. So I get what Falcon's saying, but Falcon, the whole point is that I need to hear the other side of it.
He's repeating the complaint. We can all read the complaint. We spent 2 hours going through it. The question is, what's the response going to be? We don't know.
The other side. Exactly. We got the he said, we need the she said. And then like I said, we're going to find out that the truth is somewhere in the middle.
Jamie, I thought I was being way more subtle than that, but I appreciate the compliment.
Oh. Anyway, so I think that's about it. Unless you got anything else to say, I think we should cut to Stacy and let everybody jam out here. It's getting pretty late for everybody, I think, or at least for certain people. What time is it now? Almost 9:30. So that makes it, what is it now? It's about 12:30 on the East Coast.
11:21 and 12:30 on the East Coast, which is, that's pretty early for your crew.
Well, that's kind of true. But
I
they
don't know
have
if
been sitting here for 2 hours.
I don't know if you have any international viewers, but you know.
Stacy's international.
Oh yeah, he's a snowback. He's our Canadian brother.
Yep.
Is Stacy still on?
Yeah, he's
Hey,
here.
thank
He's
you,
right there.
Stacy. I've really cool to thank you for watching this thing. I hope it was informational. Uh, on that acoustic thing, does Stacy play the banjo? Is there some banjo in that? No, I'm being serious. It
Oh,
sounds like, he said he played it on an old Yamaha, but I thought it was a Martin. But the guitar sounds really good, but it sounds like there's some backfill
he
with a
says yes.
banjo. Oh, yeah.
He says
See,
yes.
you laughed.
Hey,
Let
well,
me,
that's
let me
because I follow a comedian named Christopher Titus, and if you heard his joke about understanding banjo, you would understand why I laughed. But anyways,
this is can you see that? This is these are all reel to
vinyl.
reel tapes.
Oh.
This is all vinyl. Oh, that's a good LP right there.
Bonnie Raitt, yeah.
That's a reel to reel deck. That's one of my turntables. I love music. I love what Stacy Seabrook does.
Mm-hmm.
People with musical talent like that are just they're mesmerizing to me because I have zero. I can put on a reel to reel tape. I can put on a piece of vinyl. I refuse to load a CD or I'll stream to keep people happy outside at my ranch. But man, what Stacy does and how they can tell a story, man, the way he can tell a story, just man, he really is right up there with Bob Dylan, and Hurricane Carter, and God, he can tell a story.
Yeah, I agree. He really puts his lyrics together well. He conveys the message accurately while still, holding the melody and the everything. It's pretty good. He does a pretty
Yeah,
good job with it.
Stacy,
It's
come on
impressive.
down to Austin for South by Southwest. Let's get you a gig with the international people. There's all kinds of gigs that even aren't officially with South by Southwest that are kind of out the outskirts. You got a place to stay. Come on down. We'll have a good time. He may be the Gordon Lightfoot of our generation. I'm not sure people really like Gordon Lightfoot, but that guy was a talented or is. I hope he's still alive. Sorry, Gordon. Great. Oh, Neil Young, man. I mean, Stacy might be the next Neil Young.
There we go.
Guy
Or Paul
just.
Simon.
What's that?
Or Paul Simon.
No, let's come on. Oh, that's before Neil Young. That's just Crosby, Stills, and Nash. Anyway, but thank you, Stacy, for all you do. Thank you, Erekose, for inviting me. I'm sorry this went so long. It's kind of debating what how much involvement to have in it because anybody can sue anybody in our system. She hasn't had a chance to respond, but I think we've given it a fair approach.
Yeah.
And you made the disclaimer at the beginning, but thank you for having me again. I love helping you out, and I love the Wrecking Crew, and I love what everybody does, getting the word out about the case and sticking with the facts and trying to understand the facts, trying to develop more facts and determining whether it be scientific with Scooby. Man, that thing was so good. I was sitting down taking notes. It reminded me of being back in law school or college. I'll tell you, at Yale, they never had microbiology majors that looked like Scooby. I'll just have to tell you that. You could draw your own conclusions from that. I'm not making any statement about anybody.
Amber's about to tell you to get a room again.
Oh, geez. She's not even on, is she, Scooby?
I haven't seen Scooby in the chat here for a while.
Okay, so obviously it's not. I'm not trying to curry any, but no. Thank you to everybody. Just tuning in and trying to have a better understanding about the case is helpful to Brendan and Stevie.
Yeah.
And I sincerely believe that, and that's why I offered to become involved in answering any legal questions that come up. And that's why I got involved in this. I'm a true believer that the more informed you are, that it's good for Brendan and Stevie. And I understand there's differences and how strongly people feel for one versus the other, and I understand that people have differences of opinion on what the evidence means, but I saw this in West Memphis 3. It's like, let's get this stuff out on the internet, get it in the public, because the more people look at it, and we saw this with Brendan. I mean, there were a lot of upset moms knowing that this could happen to their middle school, really any age, but obviously, you're going to be more likely to be implicated in something middle school through high school. But I've got, how many times have you heard, I've got a son who's 7 years old, or, I've got a son in middle school, I've got a son in high school. And, just the outrage, which my personal view of it was, that just got people so incensed that when the great folks at StephenAveryCase.org, where the Wrecking Crew does, a lot of their research from, as a starting point, and then they venture out from there. But then they started looking into Stephen Avery, and it led them, not everybody, which is cool, but it led a lot of people to say at least he didn't get a fair trial, which that's all the issue is. Did Brendan get a fair trial?
Yeah.
F no.
Absolutely not. No.
And did Stephen Avery get a fair trial? And then whether you believe evidence was planted, you don't believe evidence was planted, whether this or that, there, in my view, there is so many anomalies, errors, mistakes. You don't even have to get to Colburn planting the key. You can if you want, but you don't even have to get there to say, I don't think that there was a fair trial here. J-Man, hell no. I guess that means did they get a fair trial? People have an opposite viewpoint. I'm glad they're in the channel and expressing facts about the case from their viewpoint, because that's what a lawyer has to do.
Right.
Zellner has to be anticipating what the other side's going to be arguing in their brief, trying to meet it, making strategy decisions. Jamie, I don't know if you're still on. This is where the gamesmanship comes up. But, how much do I hold back for my reply? Do I save this for my reply brief, or do I just go ahead and put this out there? And that's where, you could call that a bit of gamesmanship. There's more gamesmanship at the appellate level. well, there can be at the trial level, but you know, there are numerous strategic decisions, and you know, where it just really helps if you were in collegiate debate. I wasn't in high school, but you know all of these logical fallacies, ad hominem, and straw man argument, and on and on and on.
Right.
But really, whoever told you, remind me again, whoever puts on the best show wins. It's
That was
absolutely
Sean
true.
Atwood. That was Sean Atwood.
It's absolutely true.
Yeah. It's all theater, and whoever puts on the best show wins. That's one of his hallmarks that he loves.
Yeah, I'd say most of the time. You know, if you got who put on the best show in OJ, forget who you think did what. Who put on the best show?
The best show was definitely the defense. Yeah.
Yeah.
They were definitely, yeah.
But you got to have
but
something.
only because it was like a Jerry Springer-esque kind of, you know, display.
Yeah,
really.
yeah. You know, Judge Ito lost control of the trial about the first 15 minutes of the first day, and the best. I'll never forget it. Johnny's up there doing his opening statement, and he's basically saying, you know, the LAPD, you all have known this forever. You know, they're a bunch of dirty, no good, blah, 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 blah. Then he starts going into the lab, and he says, you know, the lab's a cesspool. And then I don't know if you all remember, but before Chris Darden, there was the other attorney, and he basically has a heart attack right in the middle of
the names that Johnny Cochran was saying.
Like, holy shit, man, we totally underestimated this. And then,
yeah, well, it was that. No, but wasn't it they hadn't been given the discovery of all the names that Johnny was mentioning in his opening argument? Yeah. So the guy just started like hyperventilating and freaking out because he hadn't seen any of these names.
It turns out he had a major panic attack, and he's like, "Who's he talking about? Who's he? Wow. You know, who's? Oh man,
he really should have taken a breath. He really, you know."
And then you had the one attorney who knows as much about DNA testing as any scientist in the world, Barry Scheck. In there, just you know, is that good lab practice? You know, why is there EDTA in you know, the test tube, but why is there EDTA on the blood from the Bronco? I mean,
right.
But if really what it is if you have the money. Racehorse Haynes, a very famous attorney in Texas, but he had the Cullen Davis trial where he got him off on murdering his wife and shooting his stepdaughter. And then later on, so he won that case. And then later on, he got accused of trying to kill the judge. A murder for hire to an undercover FBI agent, murder for hire to kill the judge handling his divorce. So I guess the daughter was killed and the wife was only shot, but there was, you know, a bunch of movies made out of it. Mm-hmm. But he'd tell the story about going up to they were going up the elevator to meet with Cullen Davis and how much they should ask for their fee. And, you know, this is way back in the 70s. Mm-hmm. And, you know, Race said, well, you know, $500,000 would have been a huge fee. But, you know, he gets up there and he says, well, it's going to be $1 million for me. And I want $1 million for the investigators. And they spent. And that's what won that case is, I mean, they had him just dead bang and a mountain of circumstantial evidence. But, You spend $1 million on an investigation back in the early 70s.
Yeah.
You find out everything about your wife that you're alleged to have shot. You find out everything there is to know. And then that's the same with OJ. You have the expert, and that's part of Kathleen's criticism of Buting and Strang, who I think are awesome trial attorneys, but she said, it was like trying to fight, trying to do this, trying to box with your left hand tied behind your back. You can get some good stuff on cross-examination, but you can't get enough. And and so some of these things didn't become apparent, but it'll be interesting. But just thanks to everybody for, whether you're tuning in for the first time and trying to get more aware, whether you're a longtime fan of Erekose and you helped him get over 5,000. Congratulations, by the way, 5,000 subscribers. That was great, but I'll shut up and let everybody
listen to Stacy.
Yeah, because I know they'd much rather listen to Stacy than me, and I would much rather listen to Stacy than me.
Right. Okay. Go ahead and mute your microphone so we don't interrupt Stacy playing. Oh, by the way, I'm playing the studio version tonight because I recently had my other copyright disputes with Stacy's studio versions of TikTok Manitowoc resolved. So I got brave enough. I'm going to play studio version tonight. Here we go. Oh, what a time to get an emergency alert. YouTube doesn't start from the beginning sometimes.
There's something going on. Freedom is in danger. Agents of the state, they taking children from the manger. Oh, they will sacrifice your kid. Take Brendan Dassey, that's exactly what they did. They needed someone, oh, Jody wouldn't flip. They looked around, saw him quick. Oh, it made so much sense. Why?
Oh, Brendan Dassey, he was Stephen's alibi.
There's something going on in Wisconsin that's not kosher. We better stop. Let's all
Take a look closer.
Oh, they will sacrifice your kid.
Oh, Brendan Dassey, that's exactly what they did.
They visit him once, they visit him twice. They make him feel so safe. Sandwiches, soda, so nice. No cameras rolling and under no lights. Who knows what went on up in Fox Hill Monday night? There's something going on. Freedom is in danger. Everything about this kid getting stranger and stranger. All we know, they will sacrifice your kid. Oh, Brendan Dassey, that's exactly what they did. March 1st, alone in a room with
Bert and Ernie.
no parent present.
And no attorney.
4 hours later, with a
Touch
touch of the knee, they finally get
Brendan to agree.
there's something going on. I said there's something going on. Oh, they will sacrifice your kid. Take Brendan Dassey, that's exactly what they did. There's something what they did. Take Brendan Dassey, oh, that's exactly what they did.
Yeah, DJ. Yeah, apparently so. The DJ's messing up. Anyways, that's about it, folks. Thank you for tuning in. Thank you, Travis, for being here. If you haven't already, please hit subscribe, and we'll see ya.